Right, so I'm going to share screen. So welcome again, everyone. We now have 6 persons, and we wanted to increase that number to get started, but we are gonna get going. I'll do the screen share so that you can see the presentation that I have for you. Okay. All right. So there is, we mentioned have about having a will. Um, so estate planning is the whole um, focus on how your assets will be distributed after leaving this earth, right? Well, it's the Bible that says that, we came in naked and we will return naked. We will not be able to take anything with us. No land, no house, none of those things we work so hard for. We really need them to make us comfortable and to live a good life. So we must buy our house, we must buy our car, and so on. But if we can't take anything with us, why not decide that you're going to be ensuring that there is a document, there is a will in place that will allow for seamless transition and passing on and distribution of your assets. So if it's the house, we must know who is getting it. So you can see that picture there where people are fighting over the house, and it's good, decent people. So everybody fight. So you think if they're in a ghetto, they'll fight. If they're uptown, they'll fight. Once it's not clear, everybody think they have a right. But just with that little document called a will, it will state who gets what and leave everything clear. So that this lovely family don't split apart just because there is no will and nobody is aware of how the assets are to be distributed. All right, so this topic is one that will try and educate you so that you will understand exactly how estate planning um, is important, that it will give you some instructions to start to examine what is happening in your neck of the woods, what's happening with the property in your family or the one that you own. Do you have a will? So check yourself, right? So you control, so estate with will, meaning that in case you pass on and you have a will, you have written a will and it's there, you have died in testate, right? So if you have no will, then you're intestate, right? So testate means you have a will. That means you have stated exactly how things are to flow, how things are to be distributed. You have no will if you die intestate. So you control and direct who inherits your asset when you die testate. You direct who administers the distribution and settlement of your estate. So there's someone called an executor that you appoint. You avoid the costs of surety bonds, and it enables orderly settlement of your estate, sparing your heirs or your loved ones from unnecessary expenses and confusion. The biggest thing is the confusion. Do you know anyone who has died intestate? Can you think of any family that is, you know, in a you know, dispute now because they haven't put a will in place? Can you think of anyone? I can think of some families. I can think of places that have been left because everyone decided that they will be hands off, and they have no monies to process the transfer, etc., pay lawyer fees. So it's there as what we call a white elephant. That's a property. There's a plaza or it's a business place. It's just there. So intestate, the laws of the jurisdiction determine who inherits your assets. So, and the laws would vary from country to country. So the government would decide who gets your house? Who gets your land? Right? So the court determines who gets that and who administers it. Right? The estate must obtain surety bond, that's in the US, and so on. Right. So let me just ask you, do you know? Let me stop the share a little bit and see how many persons I have. Right. Do you know where in Jamaica you can go to start the process if you know if a family member has died intestate? They did not leave a will. They did not leave a will. Do you know where to start? Would you know where
No.
to start? All right. Right there on Union Street, there is the Administrator General Department. And then you have to apply for letters of administration. Give them the information and they'll direct you as to what to do, right? But that's where you actually get started. Now, we're going to continue to look at go deeper into, we're taking a deeper dive into this now.
Repeat where you said. Sorry, Miss Smith.
Everyone knows NHT building?
Yes.
Right, it's just upstairs, the NHT building. This is the Administrator General's Department.
Okay.
Right. So you can apply for letters of administration. Or just look up, just Google and find them. All right.
Okay.
I'd like you to check something for me. Check to see if the recording is going on now on that channel in the chat.
Yes, it says live.
All right, great. So others can just access it if they're on the job, if they're on the wards, they can access it. Now, the will. How is this will written? So it is that I want you to be thinking about your own situation as you are listening to me. Because with information comes added responsibility. So if your parents don't have a will, you are the one who is going to be left at a disadvantage. So ensure that one is written for them, that they have one written and you know where it is, right? So basic, the person who is writing that will must be 18 years of age or over and of a sound mind, all right? So mental capacity must be good, right? The witnesses cannot be beneficiaries. So you must have two witnesses and they should not be beneficiaries. So note those, right? So the will must be written, right? And in most places, most states overseas, locally, we prefer it is typed. But someone says if it's even on a napkin, yes, and it's written, at least that's the only thing that you will have. Two witnesses sign it, but it's best it is typed. But I'd say to you, make sure you have a lawyer's input because there are some things that can invalidate a will. So you'd go through all of this, putting it together yourself, and then because you called the two witnesses at different times and one didn't see the other signing it, then they can't testify that yes, they saw each other sign it, then it can invalidate the will. So there are some little things, little instructions that the lawyer would give to you. Right? So you must name the testator. So whoever is doing the making the will, the name must be in there. You must name the executor or executrix, which is more two persons. All right, you must be signed by the testator. It must be dated. You must have a date. Right, and witnessed by two witnesses. All right, then you must name who are the beneficiaries, who are the persons who will get X and Y, and they must be specific, right? So the executor can be a beneficiary, right? Because the executor is going to be paid enough. So if it's not in, it can be the equivalent of the cash that he's expecting. All right. So the properly drafted will now, it should direct executor to pay debts, to pay the taxes and funeral expenses. It should provide appropriate share for spouse, right? And you name a contingent person. Suppose the person you name dies. You name the Pastor Brown and Pastor Brown dies. You want a cousin. It can be a family member, right? Who is benefiting. You name someone else in case of, right? For minors, you name trustees. They're underage, so you put the name the trustees. Then the will should contain any residuary clause to explain things further, right? You should waive the requirement of bonds for all persons like the executor or guardian or trustee. So that is a US thing. But all those from 1 to 5, make sure that your will complies with that. Now, look at some of the costs. When we talk about estate planning and estate taxes, did you know that your house that you have built or you bought, it costs 40 million or 20 million? In the event of death, you want that this house to pass on to your only child, you're the sole person on that title, but you want to pass that on to your child. In case of death, and you die leaving a will, so you die testate, right? So what happens next is a lot of charges, right? Because when the documents are to be processed in terms of probating and also transferring the property, it costs money. So there are some costs involved that you don't know about, you would have known about unless you learn it at a session like this. And therefore, this is where the life insurance comes in. It's important to make sure that enough life insurance is there on your life so that in the event of death, money will be there to pay out these fees. So the executor is to be paid. That same executor that's named in the will, their commission is 5 to 7%. Right? So legally, 5% to 7% of the value of the estate. So let's say it's 20 million is the value of the house. Then it's 1.4 million due to the executor. Is there anyone who's hearing this for the first time?
Very first time. Unbelievable.
All right. The lawyer's fee. All right. So we'd say as an insurance advisor, financial advisor, say to a business owner, say he owns a plaza, and we ask the question, how would you like this plaza to carry on, this business to carry on upon your death? And he'd say, oh, I've worked so hard to build it up. It's so wonderful, so beautiful. My son will just take it on and he's fine. Then I'd say, what is the value of this plaza? Oh, this plaza is about 200 million. This is many, it's upstairs, downstairs, and many sections. So I'd say, how much do you have in insurance just to make sure that in the event of your death, it is there to administer your estate? Most times they say, what you talking about? And then I say, did you know that when you pass on, that son that you're talking about who is supposed to inherit this plaza, he will not be able to borrow any money against this place or sell it or do anything with it because it's not in his name. He doesn't own it. So once it's, yes, it's daddy's, and the will says you are the person to get it, but to take the name off the title is a process. Who do you need to get to help you? You need a lawyer. The lawyer's fee is 5 to 7%, right? And so if it's 200 million, of course, it's about 11.4 there. But say it's your house, 20 million is the value. then it's 1.4 million. Stamp duty, right? $5,000, that's a fixed fee. There's other little fees that you will only hear about when processing. So you, as the child, the son, the daughter, you thought that it would be so easy to just inherit, but all of that takes on a whole new meaning when you hear of the cost, right? So there's death tax, transfer tax, and of course, matrimonial home exempted. Interest penalty now. Let's look at the bottom piece. Interest of 6% is applied for 6 years after the anniversary of the death of your loved one. If there is no transfer, there's a 6% increase in the transfer cost. And so, if your parents died, and they left the will, you're the one to inherit the house. It is best to deal with the transfer as soon as possible. So, within the first year before the anniversary of the death, if you start the process, if you are way into the process, then you can avoid this penalty of 6% of the value of the estate. All right. So interest penalty. So you have to think about that. So the government has reformed the transfer taxes. It used to be like 25%, but what they do now, if your house values 10 million, 10 million and below, there is no tax, no transfer tax there. But over that, they have like about a 5,000, 15, 25,000, and it's tiered as the cost goes up. So it's a little bit more bearable, but we as advisors would encourage you, if the estate value say 20, whatever the value is, make sure you have 15 to 20% of that value in insurance on the owner, right? So if for my home that I own, I have to make sure that there is a will and that I have insurance to the value of outside of what I need for my children's education and living expense. But there's a part that there's an extra payout for transfer taxes and transfer costs on my estate. All of that should be stated in the will. So, for example, you have the will that should say then funds for transferring the property will be paid out from policy number that payable to such a person. All right. So you have to bear these in mind. So let me give you a little time to sink that in. Right. Just take that in and decide. Think about whether you have a will. If you don't, there are will forms that the pharmacies, you can pick one up and have one written up, but you can contact a lawyer, and I can give you contact for Mrs. Harty, who had presented for us some time ago, Jenny Harty, and you know some lawyers around. All right, so there are other things. Is the list isn't finished yet? Registration fee on transmission of the property. There is also Gleaner advertisement, because just in case anybody else have an interest, you want to make sure that that has to go out there and to do it properly. There's a fee of $10,000. All these figures was from just last year in terms of, so it still stands. Attorney's fee to apply to stamp commission office. So there are some standard fees, and there are some others now, like this $300,000, a percentage of the 20 million. So ladies, mostly ladies, these costs, you will be, oh, Everjoy, raise your hand. You will just be hearing about them when you are doing the processing. And you'll be so overwhelmed with it if you don't have a life insurance plan that was paid out on your parents or whoever that died, that has that will, that you're dealing with the probate and so on, that you have the monies from that to deal with these costs. Everjoy, go ahead with the question.
Good evening. I'm already stressed with all these payments.
Yes, it's
Okay.
understandable.
My background is a little bit noisy, so I'm really trying hard to listen. But I want
Okay,
to find out if the estate doesn't have any insurance policy to cover all these payments,
right.
then whoever the beneficiary is will have to take that out of pocket. Correct?
Correct, correct.
Wow.
So what happens now is that these lawyers, and as she was mentioning in her presentation, she was saying that there are files at the lawyer's office on this transfer of property that is just sky high, reaching the roof. Why? Because the beneficiaries don't have the money, don't have the funds to come forward to do all these things, right? So due to lack of funds, so remember, the time in the court um, and the transfer takes a while, but in addition to that, you having to go and find the money, there's additional time lost there, right? So you want to have monies to deal with this. Now, this is a bit exorbitant with my estimation, but someone said, yeah, some people are spending that kind of money on funeral. I'm happy that COVID has cut out a lot of these things, the repass and well, so then they have programs. What are some of the things that are cut out? The 9 night and setup. All right, you see those costs for the funeral? Mm-hmm. Right. So I think I'd just scratch that 2 million and put 1 million or 750,000. Is there anybody who has who had to deal directly with a funeral arrangement recently for a family member or you want to share? Anybody wants to share in terms of the costs and how with COVID things have really been slashed and you're really happy for that? Anybody want to share? All right. So what I know is that all right, Everjoy, go ahead. Yeah.
I don't
You
know much, but a friend of mine buried her grandfather just Monday last, and she says the
mhm,
cheapest package at one particular funeral home
yes.
is a little over $350,000. So things are really expensive.
Wow, wow, wow.
Yes,
Yes.
the
So there
cheapest.
is one funeral home that it was 300 for the place where the interment was going to happen, and it was two something for that included the storage and other stuff, casket and so on. So they were trying to do a small package, but they had to do more than 500 and something thousand in trying to keep it minimal. So it can't go, it's hard to go below 500 in terms of keeping it minimal, right? If you want a good box and all of that. So, right. And with storage adds to it. So it costs money, and then we want to make sure that if it's even 500,000, we have on our parents' life, so that when this time comes, there is some contribution. Now, we are normally concerned about our parents in case they die. We want to make sure that there is money to spare them. But I am now telling you about an additional concern in terms of estate taxes. So once your parents own property, think about it. You want to make sure that there is a will in place and that there is additional monies now to go to these different places to deal with the transfer of the property. Now, we also need to look at this because what what happens, at the hospital and some of the private hospitals, there's a big medical bill left behind in case the person still dies, right? So we will tell you about the long list of the the write-off that they have to do sometimes, because the person would have this surgery. It's a critical illness, or they have a surgery, and then they still die. No, if you have a critical illness plan, you would have that money paid out to your account. So, mommy or daddy has a diagnosis of cancer, and the critical illness plan is paid out, whatever it is, 5 million or whatever, say it's 5 million. They go into the hospital and something else happens, whether it's pneumonia, because sometimes something else causes them to pass on. At least that medical bill can be paid, and plus there is funeral costs and all of that. So you'd have to be really thinking about everything else everything that can happen. All right. So in terms of private care, if there's a diagnosis in terms of average cancer cost, well, I paid out, even while COVID is happening, there are several diagnoses happening. There's a young lady, she got 3.2 million, and then she was filed for, she had to leave. And I said, wow, you did your surgery, you did your chemo session, and you're good. I'm sure you have about 1.5 million to buy some US and be nice. She said, Mrs. Smith, the money is finished. Based on what? Because it was stage 4 cervical. And she did well, but she got every treatment that she needed to get, best doctor, because she could afford it. Right? So please ensure that you do have your critical illness plan in place, and we know that we want to get, well, you deserve the best care. Being a nurse and so on, you deserve to get the best care possible if you should be diagnosed. And you see the conditions that our hospitals are in, and you're really, most of you, and I congratulate you again for working miracles. Sometimes you work miracles just with the things that you do. Sometimes I know that you have to go from one place to the next to get some of the medication, and it's finish on this ward and that one, and then you work and do your best to make sure that the patient gets the best treatment. So continue to do a good job. Right. So critical illness is expensive, guys. It is expensive, and so most of the treatment that follows, you won't know about it until you have that particular illness, right? And that's when you really are paying attention to that, and you really find out the cost. I know another young lady had the thyroid cancer, and the first scan was 95,000. Say, all right, now. The next scan was 300, I think 420 something, because that's with I'm going to be saying that I think they had to use mercury, or, well, it's something that had to be flown in. Anyone knows about that? So it was done on the same day that the medicine came in. So it's done at Apex in Kingston. Iodine treatment. Yes, it's an iodine treatment. Are you familiar with that? Very, very expensive but effective. It's part of the radiation therapy, but it's a very good one. And you need a few of those. And after the therapy, then you have to come back after a while and get another scan, because they have to see whether the treatment worked. And then after a while, you go back for a checkup. So, guys, make sure you can send me a WhatsApp for a quote to say at least how much another 1 million costs, right? How much another 1 million costs, so I can at least put these things in place. Surgery, you see there's 2 million here. Just the other day, a client of mine, she had COVID and had to go to one of the private hospitals. Of course, the government says 10 days is the minimum. So do you know? And of course, it's 200,000 per day. So they had to pay $2 million in order to be admitted. Of course, that person doesn't have $2 million, but another relative came, somebody came, and paid it from my credit card. So they were able to be admitted. So they have to pay that upfront. They didn't spend the whole 10 days, but you have to have that. So it takes cash, the care, and you deserve the best care. So see what you can do to get that critical illness plan. All right, I won't go into that. I want to go to the questions, right? Frequently asked questions. Now, what is the difference between joint tenancy and tenants in common? All right, your title that you get, or if you can go and look on the title that's at home. If you know where mommy and daddy put the, but for those who are young, put the title, ask them to, tell them you want to have a look at it. You will see at the bottom somewhere there that this property is joint tenancy, or it will say tenants in common, right? So it's either joint tenancy or tenants in common. So check and see what it is. Anybody has a title and here you bought your house long time ago? I'm gonna give you that homework to go and check to see, because some persons don't know that, they don't really care because that information doesn't really matter to them right now, right? But check and see, all right? So with joint tenancy, the property is owned by all surviving joint tenants on the death of one. The deceased cannot create any will to transfer or dispose of his interest to any beneficiary. I won't move on yet. Let me make you understand that. I know that's just words if you're seeing that for the first time. Anybody agree? Nurse Ava, do you understand joint tenancy? Nurse Ava, what she's gone for. Nurse Brooks, do you understand joint tenancy?
Yes.
All right, good.
Based on what you said, yes.
All right, good. So I mentioned, all right, I mentioned my parents' property having had to deal with the title, and because it's a family house, we used joint tenancy. It means that only the last man standing, the last one to die, who can will it to anybody. All right, so once one goes, then it belongs to the others, and so on. Tenants in common now, where each tenant in common owns a specific defined share and can create a will to dispose of or transfer their share. All right, so if it's you bought a house with your sister, it's best to have it tenants in common so your sister can will her portion and you will have your portion to will. Right? Two persons own property as tenants in common. If one dies, does the property automatically go to the other? No, because each can then pass on to their beneficiary. All right. If I don't have much, do I really need a will? Has anybody thought of that? You're thinking, oh, I don't own anything, so I don't need a will.
Mrs. Smith, Miss Smith,
Yes, yes, yes.
Evaja here. Can you just please just back up a little bit about the tenants in common? If one person dies.
Right. So we have two scenarios there.
Mm-hmm.
We have joint tenancy.
Yes,
So
I got that part.
all right. So in tenants in common now,
Yes.
the property is divided in equal shares, or each person will have a share, their own share. So when that person dies, it doesn't go to the next one. It is passed on to that person's beneficiary or whoever they want to declare it to will it to. Right? So they can will their part to anybody, to the church, to the sister, to the child, to the daughter, son, right? It
So
doesn't
what if
pass on to the other
so what
person
if
of time.
what if one question, what if I should pass on and I didn't have any beneficiary? Would my sister, the other part beneficiary, other person gets it automatically?
Okay. All right. Did you have a will? You didn't have a will.
No will, no will, and I die, I don't have any beneficiary.
Right. And a family member, the closest family member, can go to the Administrator General's department and apply for letters of administration on your part. So your sister who owns the other part can go and apply for letters of administration from Administrator General and start the
Okay.
process. Would take some
Okay.
time because they have to now declare that she is really the sister. Is there anybody else, who stand to
Yes.
benefit and so on? Yes, so
Okay.
thanks for that question. All
Yes,
right, so
thank you.
guys, you can ask questions. Good. All right. Now, if I don't have much, do I really need a will? You may not have much now, but you could win the lottery. You might get rich tomorrow, that they're saying then. So it doesn't hurt to prepare at, something and spare your loved ones the headache of finding your assets and paying additional estate administration fees and costs. So you can have an open clause, like, and all my assets I give to, right? So it might be what you don't consider significant because you think that is a big house that is significant or some fancy car. You have paintings that you own or you know, furniture. You can always will that, right? So all my possessions to John Brown or Mary Jones. Can I disinherit my spouse? All right. Yes. So it says no in most jurisdictions. What happened is that the spouse you can say I have disinherited. You can do it, but the spouse has the right to contest, right? And once they can prove that, yes, I'm lawful spouse, I have been contributing to the union and with proof, then yes, they can't, then they will definitely be counted in, right? So, can disinherited heirs contest my will? Technically, yes. But their chances of prevailing are slim unless it's a spouse or a minor child or disabled child. So it's hardly for the minor child or disabled child because the law protects them, right? But where you say, no, the spouse never had a contribution or so on, but they can apply and start to prove whether or not they are spouse, right? So there's a process there for the spouse, right? But it protects it. So can I use a power of attorney instead of a will? A power of attorney is only effective during your lifetime. The authority of the agent ends when you die and does not supersede the authority of the administrator or your estate, right? So it's for during lifetime, the power of attorney. That's where it ends. You need a will because it speaks beyond death, all right? You are nurses. I'm sure all of you have seen someone die in your care. Not your care, but even on the ward or so. Right? Is there anybody who has never encountered that? Everyone has. Yes, yes, yes. Because even in passing through the hospital, I saw. Right. So and you've never seen any one of them talk after they pass on, right? They've never said a word after. Well, in writing a will, that's the only way that the person can speak right after. The will is read, and you hear exactly what their wishes are for their assets and how the things are to be transferred. It says, if I have a trust, do I also need a will? All right, we're not going to go into the trust, but yes, it helps to have both to ensure that all your assets are distributed as you intended. Property acquired after the trust is created or assets not effectively put into the trust will be covered in residuary clause of the will. All right, so a trust, some persons set up a trust fund, like for children or for, so that the assets would go to this place. But the trust forms part of the estate, and the will is what speaks to what happens to the estate. So you need a will, you need a will. We all need a will. Okay? So, any questions from you now? And then we're gonna have a good chat in terms of the life insurance aspect. Questions from you? You're all trying to dissect it. Any questions? All right. What are some of the things to be included in a simple will? What do you need to have in a simple will? Let me stop sharing. What do you need to have in a simple will? Yes, Nurse Brooks. You can unmute and then.
Okay. So in a will, you need to make sure you have the name of the testator.
Right.
It's the person who is, doing the will. You need to make sure you have an executor.
Right. Two persons who are.
Oh, and yes, and the witnesses.
Right.
And the witnesses
Right.
cannot be beneficiaries.
Okay. The witnesses cannot be beneficial. All right. Right. All right. The witnesses cannot be beneficiaries. But what about the executor? Can the executor be a beneficiary? Can the executor be a beneficiary?
Yes.
Right. Good, good, good. And how much is it that it's estimated that the lawyer needs to be paid?
5 to 7% of the value
All
of
right,
the
good,
estate.
good. All right. And I must tell you that the stamp duty in Jamaica is about 3% of the 3 to 5% of the value of the property. So you'll need to be thinking about that along that line. What do you do if you, what do you call a person who dies without a will? You died what? What's the word? So,
Intestate.
intestate. All right, good. So, what's the first thing to do? What does a family member do? They test the the person who passed on never had a will. Daddy or mommy never had a will. What does the next of kin, the dependent, the beneficiary do? What's the first point of action? What or the first place of call? What do they do?
They have to apply for the letter of administration.
Yes, letter of administration, and that's the Administrator General's office.
Department.
Yes, department. All right. So at least you know where to go and you know what to do. So we're saying now you're to don't check yourself, check your family in terms of your parents, your loved ones, to ensure that they have the necessary life insurance in place that in the event of death, in the event of a diagnosis, there is a payout from Sagicor that will be at least assisting you with the administration of the estate or the final costs. You see how the funeral costs and all those final costs are expensive, and most persons don't factor in the medical bills because there might be even a surgery prior to death that the bills need to be covered. All right, so I'm going to ask for any other questions.